and happy spring. My name is Leslie, and I'm the MASSPAC coordinator at the Federation for Children with Special Needs. Welcome to our webinar today on guardianship and the alternatives. We're so glad that you're able to join us today. I'd like to give you a little background on the Federation for those of you who are new to us. The Federation for Children with Special Needs started in 1974 by a group of parents who are part of a coalition that pushed to get the first special education law in the country passed. The Federation provides information, support, and training to families whose children have special needs, special health care needs, and children who are at risk culturally, linguistically, or economically. Providing technical assistance to special education parent advisory councils and families going through transition are just two of the Federation's many projects. I will be facilitating the webinar today. This webinar will be recorded and archived at a later date on the Federation's website. Just a few technical pointers. Please be advised that everyone who's listening today will be muted except our presenter. If you have any questions, please use the webinar toolbox that allows you to type in questions, and we will try and answer them either during the presentation or I will collect them for the presentation question and answer portion at the end. Today we are welcoming our main speaker, but we are also joined by Terry McLaughlin, who is our transition specialist here at the Federation. So you can also ask a transition question for free today. We're very thankful that Hillary Dunn is able to join us today. Hillary is an attorney in the Special Needs and Elder Law Practice Group at Fletcher Tilton, PC. Her practice focuses on working with families in special education matters, as well as other areas of special needs planning, including advocacy with adult human service agencies. Ms. Dunn previously worked at the Disability Law Center in Boston and also served on the Department of Developmental Services Human Rights Advisory Committee. Currently, she serves on the board of directors for the Mass Sibling Support Network. So welcome, Hillary, and thank you for coming.
Great. Thank you so much for that introduction. I'm hoping I sound okay, everybody. It's my first webinar, so hopefully I'm doing okay technologically here. So as Leslie mentioned, I work at Fletcher Tilton in the Special Needs and Elder Law Practice Group. It's a full-service law firm, but our practice group specializes only in working with families and individuals with special needs on special needs planning issues, estate planning issues, guardianship, special education issues, and pretty much anything else that would come up that a family would need assistance with. Okay, so let's get started. This is overall just meant to be a pretty general overview of guardianship and the alternatives. I'll do my best to answer folks' specific questions, but just to keep in mind that you know, in terms of a lengthy question with all the specifics of what's going on in your situation, I'll do my best to answer it, but you know, we're trying to provide as much information as possible that's going to be helpful to the entire audience. So just a quick overview. We're going to talk about legal emancipation and important adult choices that we all have to deal with. Then we're going to go into alternatives to guardianship, as well as spending some time talking about guardianship itself. Then we'll address some common issues or questions that people have, and then just open this up for questions. And just kind of right off the bat, you know, sometimes parents say, why do I need to consider alternatives to guardianship? I'm pretty sure that I need to get guardianship over my child. And you know, it's just really important to keep in mind that not every person with a disability lacks competency in a legal sense. So not every person with a disability is going to need that level of of legal protection. So moving on. So here we are talking about somebody who is 18 years of age. That's generally when guardianship really becomes an issue. When somebody is turning 18, they're considered an adult for all legal purposes. They're presumed competent. So no matter how significant the disability is, the person is going to be considered legally emancipated when he or she turns 18. Now these years, right before 18 and right around 18, are generally incredibly busy time for your child with a disability and your family. You're dealing with a lot. You're dealing with the transition services piece in the special ed context and making sure you're getting everything you can for your child. You might be dealing with applying for eligibility for adult services from the Department of Developmental Disabilities, the Department of Mental Health, or the Massachusetts Rehabilitation Commission. And those eligibility processes can be stressful sometimes. You may be dealing with the possibility of your child receiving a diploma and ending special ed. This is all happening at the same time that you also need to be really considering what to do about guardianship or the other alternatives in terms of decision-making issues. Okay, so let's talk about the important adult choices. We all need to make important decisions on a daily basis. When you're considering whether guardianship is necessary for somebody or if one of the alternatives to guardianship would work, it's really helpful to sit down and think about all the choices and decisions we need to make, and if your person is really capable. Okay, so we have healthcare, financial decisions, advocacy, any change of residence, where the person's going to live, job selection, employment issues, emergency medical situations in addition to just our daily health care needs, asserting legal rights, defending legal claims, whether this is in a civil context or a criminal context, hiring and firing providers. If you're going to have service providers, you need to be able to monitor those services and manage those services. Of course, dealing with any crises that may come up along the way. So when thinking about guardianship, at the end of the day, what we're really talking about is surrogate decision making. So when you look at all these topics that we need to make decisions about, you really need to think, will the alternatives to guardianship will be enough? So now we're going to talk about the range of options. Now, if you've decided that your person is going to need assistance with decision making, you need to decide what level of assistance they're going to be needing. And there's a whole list of options here. Okay, and this is just meant to illustrate that you have many possible options. If you're looking at this list, we have guardianship at the top and kind of representative payee and delegation of educational authority on the bottom. The more restrictive options are at the top, and then we move into some of the lesser restrictive options. And when we talk about lesser restrictive options in this arena, we're talking about when it's a lesser restrictive option, the person retains more decision-making abilities, more decision-making authority. So first, guardianship. You can have guardianship that's full or limited. We're going to talk much more about many of these later in the presentation, but I did just want to lay them out first. Guardianship, we're talking about a court-appointed fiduciary that's going to be making personal decisions regarding support, care, education, health, and welfare, and the person is to act in the protected person's best interest. Now, some of you may be familiar with the term conservatorship. Some people may not be. A conservator is appointed to handle only the financial affairs for an individual who is not able to make informed financial decisions and has income or assets other than government benefit checks such as SSI. When we think about a guardian, we're thinking about a guardian of the person. When we're thinking about a conservatorship, we're thinking about the guardian of the estate. When the guardianship laws were, there was new laws put into place a few years ago. Massachusetts adopted the Uniform Probate Code. And in the Uniform Probate Code, it separates out this idea of guardian of the estate, conservatorship, and guardianship of the person, which we now just refer to as, that's what we mean when we say guardian. Now we're going to talk a little bit more about what a Rogers guardian means and what a Rogers order is. The durable power of attorney, healthcare proxy, and appointment of advocate, we'll talk about more later in the presentation. Now, a representative payee, That's somebody who is appointed through a process with Social Security Administration. When a person who is receiving SSI or another similar benefit from Social Security is unable to manage those funds. So a representative payee does not manage all financial affairs. They just manage those from Social Security. So if your person's only income is from Social Security, then a representative payee would be possibly enough here, and you might not be needing the conservatorship. Because keep in mind, the conservatorship is for somebody who has income that's other than Social Security. Okay. So why would you want to avoid guardianship? Well, there's actually a number of reasons why you might want to avoid it, but you know, in all seriousness, guardianship is taking away decision-making authority from an individual. It's a legal determination of incapacity. It is a public proceeding in the way that this is a public determination that somebody has been declared legally incompetent. There are a number of persons that are entitled to be notified that you are seeking such guardianship. Guardianship can be inconvenient, and there's ongoing reporting. We'll talk a little bit more about some of the reporting requirements, but there are ongoing reporting requirements that do not go away, that you as guardian are responsible for every year. It can be expensive. Why I say it can be expensive, that usually turns into the question of a parent asking, well, do I really need a lawyer for this? You know, and the answer to that is somewhat, I guess it depends. There's no law that mandates that you must hire an attorney. You can represent yourself through the guardianship process in the same way that you can with many other issues that would come up in the court. One of my colleagues likes to say that you don't have to hire a plumber to fix your toilet, but many people still do that. Some people can do it themselves, some people can't. It's a complicated process, and you know, it's really how much time you have, if you're really able to navigate the process yourself. But it's going to, at the end of the day, be a personal family decision of whether you think you can handle this yourself or whether you need to be hiring a lawyer. And finally, other alternatives do exist to guardianship. Okay, so of course there are situations when guardianship should not or cannot be avoided. If there is a need for court intervention or oversight, that's certainly a situation that there needs to be guardianship and court intervention, because after all, when one is seeking guardianship, this is a judicial proceeding that involves the court. The most common issue is that a person does not have capacity to validly execute a durable power of attorney or a health care proxy. And the final situation would be that there's really nobody else, no interested party that would be available to serve as a durable power of attorney or a in the healthcare proxy context. And before we go into guardianship more, we're just going to go over a few of the alternatives to guardianship. And really, these less restrictive alternatives should be considered and explored first, not just from a possible, civil liberties type of a point of view, but the law does really require that you look at the less restrictive options first. And if you do pursue guardianship, you're going to have to make it as narrowly tailored as possible. So one of the options, if you're trying to avoid guardianship, this is really the only one that kind of comes up and handles the special ed context. So delegation of educational authority. Oops, apologize. Okay, sorry about that, back to it. For educational decision-making authority, all of your rights as a parent in the IEP process, all your rights under the IDEA, those transfer to the student at 18 unless the parents have either obtained guardianship or executed a shared decision-making form or a delegation of decision-making form. So here, the student can either sign the form saying that they're going to share decision-making authority with their parent, or they can fully delegate the decision-making authority to the parent or parents. The types of things we're talking about is, when a student turns 18, if they retain the decision-making authority in the educational context, the parent is no longer required to sign off on the IEP. The parent's attendance is not required at the IEP meeting. Any issues about continuation of special ed services are the student's choice. It's the student's decision to make at that point. But keep in mind, if you are going to obtain guardianship, that takes care of this. This is more of if you're trying to avoid guardianship and pursue some other options, and you want to stay a part of the education decision-making process, keeping in mind how valuable special ed is and it's an entitlement versus adult services that are not an entitlement, you might want to be talking to your student about staying a part of the process. Okay. Durable power of attorney and appointment of advocate. In these situations, you're talking about a principal, the principal here being your child. The principal authorizes the agent or the advocate to perform acts on behalf of the principal. Durable means that the power remains valid despite any subsequent incapacity of the principal. And these can take effect either immediately or upon the occurrence of a specific event. So with respect to the types of authority that an agent or an advocate would have, you would have the authority to deal with the assets of the principal, such as buying or selling property, gifts, creating trusts, etc. You would have some authority in the personal decision-making arena. You can hire others to provide services. You would have some say in kind of maintaining the standard of living. In terms of advocacy, when you have the appointment of the advocate would, this would be to attend ISP meetings and advocate for services on behalf of somebody that's receiving services from the Department of Developmental Disabilities, or in the same exact context when it's the Department of Mental Health. Or just advocacy in general within healthcare and provider agency settings. An advantage to pursuing the durable power of attorney and appointment of advocate, the advantage of these is, for some folks, it's not a judicial proceedings. This is a private arrangement. They're privately signed documents. It's not public, whereas a guardianship is public. For the durable power of attorney and appointment of advocate, there's no legal determination of incapacity as there is with guardianship. Okay. There are limitations. An agent in these situations can't perform personal acts that can't be delegated under the law, such as executing an affidavit about personal knowledge. They can't make out a will, can't marry or divorce on behalf of the principal. They should not self-deal with the principal. So moving on to a healthcare proxy. A healthcare proxy is often executed along with the durable power of attorney and the appointment of the advocate. Again, there's no judicial proceedings. These are private arrangements, private documents, so you avoid going to probate court, and it can remain private within your family. Here the principal designates a health care agent. Now the authority of the healthcare agent takes effect by a written determination by a physician that the principal lacks capacity to make or communicate healthcare decisions. And if this incapacity is due to a mental health reason or a developmental disability reason, the physician must either have specialized training or experience in diagnosing or treating such disabilities, or they must consult with a healthcare professional who has such specialized training or experience. So now as a healthcare agent, you would have authority to provide consent or refusal for healthcare treatment. You would have access to medical records. You could employ and discharge healthcare providers, provide consent for admission, transfer, and discharge in the healthcare settings, and authorize treatment for relief from pain. Okay, so now we're going to move into the guardianship context. So again, just to be crystal clear and emphasize what we talked about previously with the educational delegation, the durable power of attorney, the appointment of advocate, and the healthcare proxy. Those are options that do not require judicial proceedings. When you are seeking guardianship, that requires going to court. It requires a number of documents to be to be submitted to the courts. And I think that we might have a question that has popped up.
Yeah, I'd like to just ask at this time, you've laid out a lot of the private um, uh, methods to provide support for a student. At any point, can you move into, if the student is requiring more, even though you have all of these set in place, the durable power of attorney, the advocate situation, the healthcare proxy, if the student needs more, you can move into a more formal guardianship at any time in this process?
Yes, you can, absolutely. In the same way, if you think about any person with or without a disability may have something occur in the future that they're no longer able to make decisions themselves and guardianship does become necessary. The durable power of attorney, healthcare proxy, etc., those are common estate planning tools used for every person with or without a disability. So yes, you can certainly try those first, and at some point later guardianship may become necessary, but please keep in mind that in order to execute any of those, the healthcare proxy, durable power of attorney, etc., a person must have capacity to what we call contractual capacity. They have to know what they're signing. They have to understand every single term that's completely in legal jargon that's in these documents. No, they need to understand the general purpose of the document, who they're giving authority to, what they're giving authority for, things such as that. Okay. All right, so a guardianship, here is the appointment standard. And for folks to know, the appointment standard for a conservatorship is similar. It's just, again, dealing with a person who might be unable to manage their financial affairs, their property and business affairs. And they do have such property that it will be wasted or dissipated unless it is managed appropriately. But we're really focusing on the guardianship context, mainly because when somebody's turning 18, that seems to be much more of the concern, is the guardianship versus somebody having a significant amount of assets to their name and how to best work through that process. So if you're seeking guardianship, this is the standard that's going to apply. The person has to have a clinically diagnosed condition resulting in an inability to receive and evaluate information or communicate those decisions, even with the use of whatever appropriate technology and decisions necessary to meet their own physical health, safety, and self-care. Bottom line, guardian is necessary to provide care and supervision to a person. If that's the situation you're in, then you should be looking towards guardianship. Okay, we're going to spend a little bit of time on this slide because there's a few pretty important concepts here in terms. So guardianship should be narrowly tailored. Again, I mentioned the Uniform Probate Code, the law in place in this area does require that the guardianship be as limited as possible so that the individual is able to retain as much decision-making abilities as is appropriate. So for example, if the guardianship could be limited to just medical decision-making, medication management, if a person really is just unable to function in those areas, then it should be limited as such. Now, to ensure that it is as narrowly tailored as possible, we need to be looking at the individual's particular functional abilities and limitations. Now, the medical certificate and the clinical team report. These are two very important documents in this guardianship process and in ensuring that a guardianship is narrowly tailored. I'm going to talk about them a little bit in a moment, but you should also know that the Massachusetts state website for the probate court has many forms on their website, and they're pretty well organized. And in addition to the forms that one might need to be filling out in the guardianship process, there's also some explanatory materials that are very reader-friendly. So if you are looking for some more information relatively immediately, that might be a good place to check. So now, when you're petitioning for guardianship, you're really looking to remove the decision-making authority from your son or daughter and give it to yourself, possibly, or somebody else. And to do so, you are going to need to show that the person is unable to make such decisions, which we just talked about in the last slide. So the medical certificate and clinical team reports are documents that the court heavily relies upon in this context and in its determination regarding capacity and competency. And I think we have a question that has come up.
Yeah, we have a couple of questions, and you can incorporate them into some of your discussion. This is Terry speaking. And I have three here. If one decides not to do guardianship, what's the downfall? And I'm assuming you'll talk a little bit about this.
Okay.
Can a person under guardianship vote in elections? And also, someone asked about the link to those forms that you mentioned. I think you said they were on the website, right? So maybe if you know more specific information about how to find those forms. Because additionally, people have asked about doing the guardianship on their own and going to the courthouse and getting forms.
And you mentioned you can also get the probate court online. So those are just two things that people are interested in, which would like to try to do themselves because they can't afford it.
And we also can provide the link to all the people who've registered today.
Yeah,
if you have that, so that we could do that after the webinar.
That might be the most efficient way to do that, because I can't rattle it off right now, but it is the Massachusetts Probate Courts, and I can get that link to Leslie and Terry so they can get that out to you. Just kind of going backwards, I guess, the voting. Now somebody does maintain a person maintains the right to vote unless it is explicitly taken away. However, if you are in the guardianship context, but what I would say is if you are pursuing guardianship, to make everything crystal clear and to avoid any confusion, you want to make it very clear that the person is retaining the right to vote and carve that out specifically in the guardianship decree. And in terms of not doing guardianship and any downfalls to that, that's a pretty large question. I mean, the downfalls to that are, if somebody has guardianship, there is court oversight of the situation. If you have not pursued guardianship and something happens, there's no court oversight over the situation. I mean, that would be one possible downfall. Just trying to think quickly of other. If you're a guardian, you as guardian certainly have stronger rights in your person's life and the decision making. I think maybe I can address that a little bit more when we talk about the roles of a guardian and the powers that they have.
I think for a lot of families, it's quite a surprise when their student turns 18 and all of a sudden they don't have the right to go to the IEP meeting and to sign that form. That's now invested in the student. And parents have been very involved for many, many years in the decision making and assisting their student, even if the student is involved in the transition process and developing those self-advocacy skills. It's I think, quite a change for families. So at least retaining some type of involvement in the IEP process when they're in schools is very, very important. But without guardianship, they have no legal say in the student's legal decision making. Is that correct?
Yeah, and we talked about the educational decision making, that the form where if you're not pursuing guardianship that you can execute that form, but that is limited in and of itself. Because it is revocable by the student at any time. And maybe I should have said that quickly when we were talking about it. And that can present some enormous challenges for families if your person is somebody that has some potential to possibly be receiving diploma. And you might be thinking that they're really not ready to graduate. They haven't received appropriate transition services in the special ed context, and they really need quite a bit more assistance. So whether or not your student has shared shared the decision-making authority with you or fully delegated it, if you have a disagreement with your student in that context and they want to graduate and get out of high school and end special ed services, they can revoke any delegation at any point. If you have guardianship, that can't happen, and of course you should still be trying to work with your student as much as possible, but you have the decision-making authority in that situation, not the student. And just to kind of emphasize, special education services are an entitlement. When you leave special ed, you're entering kind of the great unknown of adult services if your person's even going to qualify for additional services from one of the adult service agencies. Those services are not an entitlement. And it can be quite shocking to families, and it can be quite complicated. Maze of services, another reason why retaining authority in the decision-making process is quite important, is to be able to kind of work with service providers as much as possible on your person's behalf. Okay, so quickly, the medical certificate and the clinical team report. These are very important documents. They're going to need to be submitted to the court if you're seeking guardianship. So if guardianship is being sought on the basis of intellectual disability, that your son or daughter has an intellectual disability, you're going to need to do the clinical team report. It needs to be completed and filed. It needs to be completed by a physician, a licensed psychologist, and the social worker. Each of them must be completed, it must be dated within 180 days of the filing of the petition. So this is part of kind of coordinating this whole process. You need to get those 3 professionals to fully complete and execute this document, and that all has to be within 180 days of when you actually file a petition for guardianship. If you're seeking guardianship for a person who does not have an intellectual disability, mental health reason, somebody who might be on the autism spectrum or any other disability that's just not an intellectual disability, you need to be using the medical certificate. The medical certificate must be completed by a physician or a licensed psychologist or a certified psychiatric nurse specialist. And again, the link that I'm going to get to Terry and Leslie will have information about the medical certificate and the clinical team report. You can see the actual documents. You can see the instructions that the court gives to the clinicians that will be filling out these documents. So that might be a good use of your time to look those over a bit, but just please keep in mind that they're very important. They need to be submitted to the court when you are seeking guardianship. Okay. So the role of the guardian, this slide is packed full of information about the powers and the duties of the guardian, and I'm not going to read them all to you, but I do want to point out that the guardian is going to be making personal decisions regarding support, care, education, health, and welfare. As guardian, you should be considering the expressed desires and preferences of the protected person, and you should be acting in the protected person's best interests. The bottom line is the guardian has all the powers and responsibilities of the guardian of a minor. And that's in some ways a pretty easy way to think about this. Okay, reporting duties. This was one of the pieces that I talked about and why some folks would prefer to avoid guardianship if possible. The reporting duties for some folks, they feel they're pretty onerous. Within 60 days of your appointment as guardian, you have to file a report, and annually you must do so annually from there on after. The report must include information regarding the person's mental, physical, and social condition, living arrangements, services they're receiving, how many visits and how much contact the guardian has had with the individual, if the person is institutionalized, whether such institutionalization should continue, should address plans for future care, and finally recommendations on the need for continued guardianship. Now, if you are dealing with a conservatorship situation, some folks there feel the reporting duties are actually even more onerous because you're reporting, you're submitting financial reports and have to have pretty darn good documentation and accounting abilities too. And I don't mean accounting as in you have to be an accountant. I just mean you have to be organized and have all the information presented in a readily accessible manner. Okay. So quickly, who can be guardian. Any qualified person over the age of 18 can be a guardian. Very, important part of this is who a court is going to look to. There's a prioritized list of people that the court is going to look to of who would be a guardian if one needs to be appointed. If the protected person themselves has nominated somebody through the durable power of attorney, they're going to be looking to that person. If the protected person is married, then who their spouse is and whatnot would play into the picture. We're often talking about the last situation here, where the court's going to be looking to the parent of the protected person as the priority person of who would be a guardian for this person, or you're going to be looking to a person nominated in the parent's will. This means that in a parent's will, a parent can be naming successor guardians. I am a successor guardian named in my parents' will. My parents died tomorrow, I would be my brother's guardian because it's clearly explained so and clearly designated in their will. And I think we have a question.
Yes, we have a question, and it says,
These speak to the reporting process.
yes, it speaks to the reporting. So it says, one of the ramifications, basically, if the reporting isn't submitted, and are there letters sent out to guardians by the state
in order to
remind them?
And is there
And is there a specific date that's designated every year that things have to be submitted? So just a couple of questions around the reporting. It says another one is after guardianship has been established, the annual forms that need to be submitted and mailed to the court, mailed out by the court to the guardian. So
where's the
is there
onus?
back and
Is
forth
it on
communication?
the guardian, or is the court help you out and send you stuff? And that probably doesn't happen. I think
Yeah, this is one where in my practice at my firm, we send out the paperwork to all of our clients. So they get a reminder every single year, and we send it out to them every year so that they are aware of it. And really the onus is going to be on you to complete it, and the ramifications for if you don't submit the forms is you can be removed as guardian. Okay.
Thanks. That should be clear.
Okay. So how you start this whole process of seeking guardianship is by filing the petition for guardianship. And again, we talked about the medical certificate and the clinical team report. One of those documents, whichever situation you're in, is going to be part of what initially needs to be submitted to the court. And once you submit the petition for guardianship, you then are basically sitting around and waiting for the court to schedule a date, and you're going to have to go into court for a hearing on this matter. If it's an uncontested guardianship and there's no major issues that the court sees, this can be relatively quick and routine, but you just kind of never know how things are going to play out. Part of the process before you go in for the hearing, so when you do petition for guardianship, is there are a number of folks who must be notified that you are in fact seeking guardianship. The persons notified has been greatly expanded under the Uniform Probate Code, which is a law that has just gone into effect over the last few years. The parents and the siblings of the person are going to need to be notified. There's a whole laundry list of the folks here. Something to keep in mind is if you have a son or daughter at a residential school and that residential school is serving as a representative payee, they're going to have to be notified. And the protected person themselves is going to have to be notified. So if your son or daughter is at a residential school, sometimes the notification is then sent to somebody at the school to then serve your son or daughter in person if the residential school is basically too far away for it to happen any other way. Another thing to keep in mind is if your person is going to be looking to the Department of Developmental Disabilities, DDS, to get services from them as an adult, and they're already going to be eligible for that. DDS is an interested party in guardianship proceedings, so they are going to have to be notified as well. And I will say that this notification piece is a part that, parents who are trying to do this themselves without an attorney, this is a part where people get tripped up, and where having an attorney work through this part can be a little helpful, just to manage it and get all the notices out to all the appropriate people. Now, in this process, the protected person, the person whom you're seeking to get guardianship over, they have rights during the proceedings, as they should. They have a right to counsel if they so request it, or if the court itself, for one reason or another, thinks that there is a need to have counsel appointed to the protected person throughout the proceedings. If there's some reason that the court has concerns about it, counsel can be appointed. It's free it's at public expense, so it would not be of any cost to the protected person themselves. The person has a right to be present at the hearing. That is if the person exercises this right. In many situations, the person is not present at the hearing, and that's family decisions. Clinicians need to be involved in kind of deciding whether or not it's going to be appropriate for the person to be present at the hearing. However, if the person does exercise the right saying they want to be present, they do so have such right. We already talked about the right to have the guardianship limited. All right, so the limitations of a guardian. A guardian cannot admit or commit a person to a mental health or I say MR because I don't like saying mental retardation, to an MR facility, but that is how they are still referred to in the guardianship context. They cannot admit to a nursing facility, and a guardian cannot consent to treatment decisions requiring a substituted judgment determination. We'll talk about that final point a bit more in the next slides. And when I say a guardian cannot do these things, a guardian cannot do them without going to the court for a specific court approval to do any of these. So it's another step that you would have to take. When you're just going to get general guardianship, you do not automatically have the authority to do these. You need to have specific court approval to do one of these. So procedures requiring a substituted judgment determination. The guardians must get court approval to consent on the behalf of the individual to any extraordinary treatment decisions that are not considered customary and usual. The most common issue that comes up is antipsychotic medication. If your person is going to need to be treated with antipsychotic medication, you are going to need to get a Rogers order. This is an extra step that you have to go through in the guardianship process. The standard that is applied here is if the person were competent, would the person consent to such treatment? The court is going to consider several factors when making the substituted judgment determination. They'll consider what the protected person's expressed preference may be, what the protected person's religious beliefs may be, the probability of and extent of any side effects. Many of these antipsychotic medications are very powerful medications with some pretty significant side effects, and that is taken into account. The prognosis for the person, if the proposed action is allowed, the prognosis without the proposed action. And finally, the impact on the protected person's family. Now, the other things listed here are other procedures requiring substituted judgment determination. ECT would be one that does come up from time to time. Some of these other ones are fairly rare. By far, the antipsychotic medications is the most common one that's going to come up. If you have questions about whether a specific procedure requires a substituted judgment determination by the court, my advice would really be it's better to be safe than sorry in this context. These treatments and procedures are taken very seriously by the court. Oh, we have a question.
Yes, we have a question. This is Terry. If you have a healthcare proxy, can you do these items more easily than requiring court involvement if you have guardianship?
Okay, so I think what the person is getting at is the administration of the antipsychotic medications, possibly. You will need a Rogers order to administer antipsychotic medications to a person. You cannot do that just through a healthcare proxy. And there is a defined medications that qualify as antipsychotic medications, so I'm not kind of using the term antipsychotic in my own parlance. There's very specific medications that qualify as that. So if you have specific questions about a medication that your person is on or maybe using, you should be speaking to your clinician about whether that qualifies as an antipsychotic medication. Okay, so the termination of guardianship, removal of guardianship. Basically, if guardian is not acting in a protected person's interest, they could be removed. Sometimes the issue does come up that the guardian themselves becomes disabled later on in life. And the guardianship is going to terminate with the death of the protected person and in these other situations. But removal happens from time to time, and it can get a little bit messy. But as long as you're generally making decisions and acting in the person's best interest, fulfilling your reporting requirements, you should generally be okay. All right, so this is kind of our final slide, and then I will address a couple other questions if there are still some. So I just wanted to hit a couple common issues or questions that people have. I'm actually going to start with the last one first, selective service. So this actually doesn't really have anything to do with guardianship in some ways. It's just an important issue that comes up for folks, for men who are turning 18. So within 30 days of their 18th birthday, men must register for military duty. Now, you have to register at your local post office. Disability status does not relieve you of this duty to register. And technically, a person could be denied Social Security benefits if they're not registered. How much does that happen? I don't know, but technically you could be. So better be safe than sorry and take care of this. Now, guardianship timeline. I know we received a question that was submitted ahead of time from a father asking about their 15-year-old son with special needs, and they're looking to get guardianship when he is getting close to that age, and what should they do. I think we've gone over some of the nuts and bolts of filing the petition, the notification requirements, medical certificate, and or the clinical team report. But the big question that people, I think, have is when do we start this process? And there's no perfect answer for this. Any good lawyer always will say it depends, and every client will get incredibly frustrated with that answer. But it really does depend on the case. But generally speaking, you probably should be starting by the time your person is 17 and a half. You just think about it in the context that from the time you file the petition to the time you get your court hearing on the petition,
You're generally talking about 2 to 3 months right there.
right
In the
there.
best case,
Best
you're
case,
talking
you're
a month and a half.
file
File the petition. The time you get
hearings
hearings in court.
So Hillary, if I could ask, is the goal to get the guardianship established prior to age 18 or just coincidentally around the time of the birthday?
Yeah. So again, this is kind of answered within it depends, and here it depends on the county that you live in. As difficult and unsatisfying as that may be, some counties will not let you file the petition until the person turns 18. That's very difficult for a family sometimes because you're operating under the idea that I want guardianship in place when my person turns 18. I don't want to be filing it when they turn 18. But that is just the unfortunate kind of variety of how different counties practice. Most counties do allow you to file prior to your person turning 18. So if you do so, if you're allowed to do that, you should be doing that. Now, some counties will not let you get a hearing date until the person turns 18, because technically, by statute, it's talking about obtaining guardianship over an adult. So an adult is 18 or older. So that's why I kind of said it depends, but generally you're talking about starting around 17 and a half. If you need to complete a clinical team report, you need to be starting that. You need to, at the 17 and a half, you need to keep in mind that it's going to be taking you a few months to get it all completed by the required clinicians. You know how difficult it is to get your doctor to fill out the easiest of forms. We're talking about that magnified because some doctors are familiar with it, some aren't. Some are going to spend significantly more time with this document than others. And you need to be getting it completed and signed by the physician, the licensed psychologist, and the social worker. And some school districts will not allow their school psychologist or school social worker to complete the clinical team report. Some allow it, some don't. So if you're in a situation where your school district is not allowing their school psychologist to complete the psychologist portion of the clinical team report, that puts the onus on you as a family to go out and find a private psychologist to do this if you're not already working with somebody. Many families aren't. So that's also built in time because you have to find the private psychologist, and depending upon the psychologist, they may or may not want to spend a significant amount of time assessing your child. They're going to have to assess them to some level and review records to some level to be able to fill out a document that they're signing to saying that they're recommending that this person has no capacity. And I think we had a question that popped up. Okay.
With the Rogers order, does the court have to approve every time meds change?
Yes. Well, if it's an antipsychotic medication, yes. And there's a couple folks that are going to be involved. If it's a Rogers situation, there's a Rogers counsel, meaning that a lawyer is going to be appointed immediately in a Rogers case, and they're appointed for the person over whom you're seeking to get to administer the medications to. So that person is going to be involved in the process, okay? And then once a treatment plan is approved by the court, there then is a Rogers monitor appointed by the court. And now unless there's some reason to do otherwise, the Rogers monitor is generally the same person as the guardian. That person has the responsibility, the monitor's job, to making sure that the clinicians are administering medications appropriately, that the plan continues to be appropriate, to notify the court of changes, and to notify the court of any unwanted side effects.
Okay, we only have a couple of minutes left, and I have a number of questions. A couple of them are around IQs, talking about kids who have IQs just below the normal range, and other factors besides IQ that can be considered. And I think, personally, this is Terry, this is around, I think, parents of kids who may be eligible for DDS services, and it's all talking about IQs, and they're really wondering what they should be doing. So I think the IQ issue and the intellectual disability and how it's defined is curiosity to families.
Okay. So the IQ piece, as many folks know, plays very much, is a large factor for if you're seeking services from the Department of Developmental Disabilities. In the guardianship context, it's one of a number of factors, as it's supposed to be in the Department of Developmental Disabilities context as well. But guardianship, it's really looking at the person's functional capabilities and their capabilities to keep themselves safe, the self-care, all of that. You're talking about the guardianship, the slide that had the guardianship appointment standard. That's what we're looking at. IQ is one factor of many. And really, at the end of the day, if you're doing it based on intellectual disability, the clinician is going to have to make a determination of whether they feel the person has an intellectual disability or not. And the IQ is one of the factors, but really look at it larger picture of the functional capabilities of the person.
Okay, I think that's helpful. I think it's always going to be challenging for families when we talk about the guardianship and the intellectual ability and who feels they need a guardian, others feel they don't. I mean, I think it really speaks to the importance of self-determination, self-advocacy, so the students can begin participating in a meaningful way in these two meaning
If you're somebody
who has a child that's
somewhat on the
fence, getting services from the Department of Developmental Disabilities, or that's something that you're concerned about,
whether
they will infect the eligible, it might be a good idea to talk with a lawyer about kind of some strategies or some issues that may crop up in the eligibility context if to pursue guardianship in a certain way, or if guardianship is not pursued. These are all very individualized situations, so I don't want to give specific advice, but I do just want families to be sometimes and seeking adult services should be part of the same conversation and how one affects the other.
There's a question here that speaks to if you cannot file until age 18 in a certain county. Is there a process for temporary guardianship in the
There's
interim?
There's a process for temporary guardianship. There's information on the website, the link that I'll give you. Oftentimes, even if it's not in place right when the person turns 18, you're talking about very shortly thereafter. So for many families, they are comfortable waiting until it's in place very shortly thereafter. But there is a process for temporary guardianship, yes.
Just really
quickly, I just want to point out, if people are using the Adult Family Care Program through Mass Health, it's a Mass Health service. You need to know that you cannot be the adult family care provider and the guardian. So in that situation, you're going to have to see if maybe one of the parents could be the guardian and the other person stays as the adult family care provider, or explore other options if you really want to keep the AFC program in your home. Okay.
I have a quick question here. Can a parent on Social Security disability income become a guardian? Are there any restrictions there? The SSDI?
No, if a person themselves, if the parent is receiving SSI or SSDI, they, in a particular situation, there's going to be issues, but generally speaking, that is not a barrier to serving as a guardian for yourself.
Oh, I'm sorry. They couldn't hear the question. I was asking, can a parent on SSDI, Social Security Disability Income, become a guardian? You're saying yes.
Generally speaking, yes. Of course, there's things that crop up, but generally speaking, that's not a barrier.
And there was one more question here. Can someone under guardianship be placed in short-term, say 30 days, nursing facilities for respite care?
So
someone under guardianship be placed 30 days short-term nursing care for respite only?
If it's, there's different respite situations, so I'm automatically kind of thinking of what exactly, respite is defined in very particular ways under DDS, for example. But a guardian needs specific authority from the court to admit somebody to a nursing facility. Same thing for a mental health hospital, so even if somebody is having a mental health crisis that it seems as though it might be alleviated in after a week, for example, of receiving inpatient treatment, a guardian cannot, without specific authority and court approval, otherwise they cannot commit the person to a mental health hospital.
Okay, even though it says it's for respite, it doesn't matter because of the facility itself.
That's my understanding right
Okay.
now. I apologize if I'm not fully aware of.
Well, thank you so much, Hillary. I know it's difficult to answer all the specific questions, but you've given us a wonderful background on guardianship and the alternatives. I think families have different options. I know today I learned that the guardianship goes to the person, and you can also have somebody else be a conservator and follow the estate and the money, and you can kind of have some dual roles here. I thank you for your time today. This webinar will be archived and put on the Federation website so that you may be able to listen at a later date. We will get the link out to the forms to all those people, and we'll add it either on the slide on the archive version, and I will also try to get the link out to those people who registered for the webinar today. So thank you very much. Thank you, Terry, for assisting us, and have a great day, everyone.
Thank you.